Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome to another episode of Estates Made Simple. It's always good to podcast together, and Jenna, appreciate you taking time out of your schedule so we can have these good conversations and share our thoughts and ideas with our welcome to the podcast.
Thank you. Excited for our conversation today.
Yeah, so one of the things that an executor has to do is evaluate and develop a communication strategy and decide how are they dealing with the beneficiaries of the estate. And there's different types of beneficiaries, different classes of beneficiaries, and there's duties and responsibilities that attach to each of those. So we're going to talk about reference to a legatee beneficiary and a residual beneficiary. Sometimes a legatee is also referred to as a non-residual beneficiary. If you've gone through as an executor, you've gone through the probate application, you'll see that reference in the probate application material. But we thought and identified three different areas that there's a difference between those two. So we want to talk a little bit about what are the differences, first of all, and then how do you, as an executor, treat them differently? What are the things to be mindful of? Because it's not a one size fits all. You just same thing for everybody, right? You got to distinguish between somebody who is a legatee and somebody who is a residual beneficiary. So Jenna, why don't you kick us off with the first of the three differences between those types of beneficiaries?
Of course. Thank you. So maybe I'll just back up first and explain what a residual beneficiary is. A residual beneficiary is really when you see in wills an individual receiving a fraction of an estate or a percentage of the estate. That's a clue that they are a residual beneficiary. So it's a percentage of whatever's left over after expenses, debts, and legatee beneficiaries are paid out. So for that reason, residual beneficiaries are more affected by the actions of the executor and the course of the administration. So expenses for the estate are paid out of the residue most often, and income for the estate is typically added to the residue. So the amount that the residual beneficiaries are receiving at the end of the day is really affected by the income and expenses that are paid within the estate. And for that reason as well, the residual beneficiaries want to keep a really close eye on the accounting of what the executor is doing. So every line item to consider if it's a prudent expense and to ensure that the necessary income is flowing into the estate. And the executor needs to provide, of course, accounting to the beneficiaries because they need to be kept in the loop as to what's going on in the estate.
Yeah, it's a great point. It's interesting. In terms of the notices that go out from the court, it even specifically says, listen, it's the beneficiary's responsibility to monitor the actions of the executor. There's some people who say this came from the court, so the court supervise it. No, the account there's no sort of probate police out there that is checking in. Are people doing the right thing? It's up to the beneficiaries and typically the residual beneficiaries, right? If somebody says they get a gift of $10,000 because they're specifically named as a legatee in the will, all they're interested in is give me my $10,000. And once they have it, they're done, they're out, right? They have no more interest in the estate. So I appreciate that distinction between that. So fundamentally, then the executor is reporting to and accountable to the residual beneficiaries. And there's that fluctuation, right? So that their decisions can have a material impact on the gift to a residual beneficiaries. As you've correctly pointed out, the income and the expenses can impact those residual beneficiaries. So they're going to take a good hard look at the decisions that were made and how that comes out.
Absolutely.
Yeah, and I think that's that first point then about, as just to summarize, then there is that impact of the decisions of the executor. If you pay too much on an expense or you don't collect enough on an asset, that's ultimately what you're accountable to the residual beneficiaries for. And maybe there's a complaint about some of that stuff. So ultimately you have to work your way through those things. And you better believe the residual beneficiaries are going to go line by line through that and say, how come you spent this? Or what do you mean you only sold the house for this much? That seems a little bit low. And those could be areas of contention that would involve an application of the courts to do that. Ultimately, that's who you're accounting to, right? We find that if we're just giving the gift, we might get a simple acknowledgement saying they acknowledge they received the gift. That you could argue isn't even required, but sometimes a T would be asked to just acknowledge receipt and that they have no further interest in the estate. But the residual beneficiaries have to sign off on that financial report. So that report has to be made, and the residual beneficiaries would say, yep, that looks good, and give me my share. If there's a disagreement about it, then we go from an informal distribution to a more formal application of the courts to get the court to approve what the executor has done if there's any contention with regard to there. I think the second point that we highlighted here in our outline would be that there's a difference in the amount of time. So when people receive their gift can be materially different. And yeah, typically what we see is that if you are a non-residual beneficiary, or referred to as a legatee, that they are typically paid first, not immediately. Don't expect your check a month after the funeral. It's going to take a little bit of time to collect assets and do an evaluation or determination of what's in the estate. Now, typically, if the estate is solvent, there's sufficient assets to pay the bills, and there are no particular claims, then those beneficiaries can be paid first. If there is litigation, then that kind of stops everything. Then unless approved by the court or by all parties involved, you wouldn't see any distributions. If somebody's coming along saying, I think the estate is mine, or I'm going to take a good chunk of it, we don't know if there's enough to pay all the specified beneficiaries, the legatee beneficiaries. From that perspective, you would want to ensure that there is sufficient, that there are no substantial claims being made, and that there's sufficient liquidity in the estate to be able to make those gifts. Because otherwise, if it turned out you shouldn't have made those gifts, there can be some exposure or some liability with regard to that. There's a 6-month limitation period for people to make claims. It could be that the executor is feeling like, let me wait until any of those claims are made, especially if there's a possibility. There's surviving adult or dependent partner or spouse that might make a claim. There's a threat of some litigation from a creditor, circumstances that would give rise. Maybe the person passed away because they were involved in a significant accident and there was personal injury. So we don't know, is the person going to file a lawsuit? Is there enough insurance coverage? So there is some caution to you don't want to distribute immediately. But in the normal estate where there's sufficient, there's plenty of money to pay these, and given the size of the gift, those can happen a lot sooner and will be dispersed out. Whereas the residual beneficiaries take a little bit longer, and you want to get further administration of the estate before you're considering an interim distribution, or ultimately getting a clearance certificate, a final clearance certificate to do a final distribution.
Mm-hmm. Yeah, and I think you bring up a good point for our listeners to consider, that if the estate does not have enough money to pay all the expenses and debts and taxes and etc., then the residue is used first. And if all the residue is eaten up, then the expenses need to come from those legatee gifts, those specific gifts in the will. And that also in terms of a planning approach, when you're considering which beneficiaries to identify as a legatee beneficiary and as a residual beneficiary, legatees have a little bit more certainty in what they're receiving, whereas residual beneficiaries, of course, there's more uncertainty.
Yeah. And of course, it's all subject to enough in the estate to even pay them.
Yeah.
Regardless of which type of beneficiary, it's a good point to emphasize, a good point you made earlier, saying if it's an insolvent estate and there's nothing going to any beneficiary because there's not even enough to pay the creditors. It doesn't matter if you were named in the will, and the same would apply if it was an intestacy situation, that now you're dealing with having to negotiate with the creditors so many cents on the dollar. But assuming we have enough to at least go to the beneficiaries, then the legatees would be paid first. It's interesting that what comes up sometimes from a planning perspective is, well, when you're drafting your will, do you want to do a specified amount or do you want to do a percentage? Because you could have a situation where if you give particularly a larger gift and then the balance to residual beneficiaries and you don't update your will, and then it turns out your estate gets smaller and smaller, which could happen. You make a good point, and maybe just to emphasize that we're talking about estates where there is sufficient funds within the estate to even pay residual beneficiaries. If there's not enough money even to pay creditors, we don't get into the residual or legatee beneficiaries. So assuming there is something to be distributed, it's interesting to think about that relationship between those that have a specified amount and those that have a percentage. From a planning perspective, one of the things you got to be careful about would be if you give a specified gift at the time that you draft your will, but then you leave it for a long time and don't adjust it. It could be that your estate is a lot smaller at the time of passing compared to when you drafted the will. So in your head, you're going, I'm leaving $50,000 to this charity. And in your head, you're going, that represents a certain percentage of your estate. But it could very well be that by the time you pass away, that percentage is a lot different. Typically, if your estate is going down at the later parts of one's life because of higher expenses with care facilities or medical expenses, we would be in a situation where that gift is a higher proportion than maybe what was originally intended. So a little tip from a planning perspective, if you have a specific legatee beneficiary named in your will, you always want to make sure, is that still the right amount? Is that the right proportion to what you want to go to the residual beneficiaries? Because the residual beneficiaries, as we've said earlier, is the one that fluctuates.
Absolutely, yeah. And I think that brings us to our third point and how they differ is with respect to the information that we share with the residual beneficiaries versus the legatee beneficiaries. Residual beneficiaries are typically provided a full copy of the will, get to see a full accounting, as we noted earlier, and get to challenge or ask questions with respect to decisions of the executor. Whereas legatee beneficiaries typically are only provided the section of the will that applies to them, as well as very limited information with what other actions are taken by the executor, because their gift isn't really affected by certain decisions the executor makes. There is a little bit of that fine line of telling the legatee beneficiaries enough, but not too much to affect even the privacy of the estate administration, because certain things really aren't applicable to the legatee beneficiaries. And as executor, you're stepping into the shoes of the deceased and really navigating the different classes of beneficiaries in the proper way.
Yep, exactly. You want to be careful. You need to share enough information for them to confirm that they have received their interest in the estate. How do they know? You can't say, oh, by the way, you got a gift of $50,000. They're entitled to verify that, right? And just because you say so doesn't make it, if you will. You need to back that up. But that's where you don't want to share everything, right? Because you may run into problems with that as well. So you want to be careful with regard to that. And then I think the converse of that, of course, with the residual beneficiaries, the surrogate rules require that you make adequate communication with regard to what you did. They need enough information to evaluate, and obviously a lot more information specifically with regard to the work of the executor as it goes along. So yeah, some good points to make, and obviously if there's questions on that, if those are where you go to your professionals to say what's the right way of communicating here, and seek the advice to make sure you don't guess wrong and get yourself into some trouble on that. So some good points on that. And not every beneficiary is the same. So you have to evaluate how you communicate and what you're sharing and how do you deal with them, the timing of those gifts, and what actions you take in terms of meeting your legal obligations as the estate administrator.
Yes, I think those are some great final comments, and thank you everyone for listening. We appreciate your support, and please subscribe to wherever you listen to podcasts, and come visit us on YouTube. We look forward to seeing you and hearing from you next time.
Thanks, Jenna.